the program itself was called The Perfect Storm. And what ended up happening is that I view this as a different terminology. And I use the terminology of avalanche, or as it's called in Hebrew, mapoleth. And the reason being is because you have a convergence of so many different things going on. We've got FATCA, I've got the IRS, I've got Mas Achnasa, I've got OECD, all these different types of things happening. And consequently, what ends up happening from a practical, pragmatic perspective is that everybody wants information and they want money. And I was thinking, what's a good way to introduce this? And recently I heard the following story, and it can give you a little bit more insight. There was a discussion as to what is the appropriate amount of tzedakah to give under various circumstances. So there were three people there. There was a priest, there was a rabbi, and there was an agent from the IRS, or Mas Achnasa. And in order to ascertain exactly how to figure out how much tzedakah to give, so they basically did as follows. They drew a circle. And the priest said, okay, this is real easy. I'm going to throw up this large pile of money. And whatever falls inside the circle will go for charity. And everything else belongs to me, or to the parishioners. And the rabbi said, no, let's do it the other way around. Let's throw all the money up. And in fact, everything that falls inside the circle, which is a little bit distant away, will go for the individuals, and everything outside of that will go for charity. And then, sure enough, the revenue agent from the IRS, or Mas Achnasa, says, gentlemen, I appreciate your perspective, but in reality, there's a better way to view it. And that is as follows, which is that, here's what we're going to do. We're going to take this large pile of money and we're going to throw it up in the air. Whatever the good Lord wants to take, he'll take it while it's still in the air. Whatever else lands on the ground, I get. Now, I understand that much of what we're talking about is unnerving, because you say to yourself, we live in Israel. The last time I had connection to the United States was either because of birth or something of that sort, okay? Or when I got my green card or I became a citizen. That was a long, long time ago. Why should the United States government want to feel as though they're entitled to a chelik today? And we've gone through all different types of gyrations in this process, and what ended up happening at the end of the day is that we really have a new solution. So what I want to do in the allotted time is talk about what the programs used to be, what the programs have been migrating to be, and what the new improved approach. I understand, please, that in the past we've been told by our esteemed colleagues from the IRS that, get in, it's only going to get worse. Well, the good news is that there are some new alternatives today that weren't available before. Again, there are some risks. And much of it, although it has been mentioned before, I think by Philip and my esteemed colleagues before, that much of what we as practitioners need to do is have a degree. But it's not so much a degree in the law. It's not so much a degree in the expertise. But in reality, it's a degree in psychology. And I must tell you that, and I joke with the clients, and I say that they pay me to worry for them. But it's true. Because part of what I have to do is ascertain the mental psyche of the individual and ascertain in particular how much risk as opposed to how much certainty a person wants to have. So by way of general background, basically we have as follows. We've got a US citizen or a green card holder. It used to be, there was various programs. There was 2009, 2011, 2012. And then there's a brand new intro as of June 30th, 2014. But the real question becomes one of, the program itself basically meant as follows. 8 years, income tax returns, 20% penalty. That was under 2009. The good news is I think almost all the cases under 2009 have been settled. 2011, it increased to 25%. Most importantly for Israelis, there was an opportunity to have a reduced FBAR penalty, and meant as follows, that you would take the high balance from the eligible foreign bank accounts, aggregate it, look at the largest year, and then take 5% of that, and that would be the way to settle the case, in addition to the income tax side. And then what happened is that, of course, they had some limitations. And one major limitation on that program was that they said that you could not have more than $10,000 of U.S. sourced income. Yes, you might be able to use the treaty to protect Social Security payments. And that the problem also was the fact, ladies and gentlemen, that under the 2011 program, even if you filed a U.S. tax return and were fully compliant for the jurisdictional-based income of the United States, it still knocked you out technically to be able to get the 5%, which really wasn't fair. In essence, what happened is that you got penalized for having U.S. income, and not only that, for paying U.S. income taxes. Okay, now, what ends up happening, though, is that in 2012, they increased the FBAR penalty from 25% to 27.5%, and then they introduced something in September of 2012. And I use this backdrop so you can really appreciate where we are going today and what the opportunities are, even for those that are still in the program. So the initial program for Streamline was 3 years tax returns, 6 years FBARs, but again, the IRS didn't get it up front, and they said, we want to have these to be low risk. And what was the stated definition for low risk? Any amount of tax which was below $1,500 per year, and you couldn't say, well, if the aggregate of the 3 years tax returns brought the average down below $1,500, I would satisfy. Each year stood on its own. And of course, very little feedback, and technically there was no protection. Now, again, there were a lot of people who used this technique, but still at the same time, what ended up happening is the fact, if a client comes in, ladies and gentlemen, and says, I do not want to take any risk. Can you assure me that this will work? Well, technically, if you look at the guidance that was out at that time, although we were being told by the IRS, we don't mean what we say, we actually mean to be more liberal. Ladies and gentlemen, if an IRS agent or an agent from Mas Haknasa comes and tells you, don't worry what it says in writing, trust me, would you believe them? Okay. No, again, please understand that there are many, many honest, sincere IRS people. Okay, but this is that was the stated policy in those times. Okay, so now what happens is that the good news, at least under this approach, was the basket of the FBAR penalty did not hit and did not include those assets that you may have bought overseas. Big difference as opposed to the offshore program. Okay, so now what happens is that comes June 18th, 2014. And they came up with a brand new voluntary disclosure program. We'll talk about that shortly. But also a new revised streamlined program. And what you've heard about is this concept called non-willful. Now, ladies and gentlemen, if I asked you to define non-willful, what would you say? In Hebrew, you would say, Ze lo haya b'mezid. It was not done intentionally or willful. But heretofore, right now, the IRS hasn't really given us much guidance. So what ended up happening is as follows, is that, and I'm going to use a biblical analogy. It meant that this is classically known as the anti-Nachshon ben Aminadav situation. What do I mean by that? When Bnei Yisrael was leaving Egypt, they came to the Yam Suf. And the problem is that the water wasn't split. Let's forget about what the movies say what happened. Let's go to the Bible. And sure enough, a very, very special person by the name of Nachshon ben Aminadav, he jumped in. He was the first one, and a miracle occurred, and the water split. So in that situation, the zrizut, the diligence, and therefore the aggressiveness of it was viewed as a good thing. Here, many of my colleagues either entered into the new streamline, or what they did is they transitioned from one of the new things that the offshore program that was just introduced noted was you could transition into the streamline and say, I really wasn't willful. It was a mistake. It was something similar to that. Almost every case that went in subsequent to the introduction of that information in June got rejected. We told our people, as though we were getting a lot of pressure, wait. It's too new. I'm concerned that there's going to be pushback because here the agents have been told one thing. These are the rules. Now all of a sudden you're changing the rules. And I was concerned, as well as many of my colleagues, that there wasn't sufficient information, guidance, and education given to them. And sure enough, that's what happened. The good news is, over the last 6 months, they have begotten much more familiar with the concept of non-willful. And what I'd like to do is emphasize the discussion of the non-willful side. But before I do that, please understand that there are certain criteria that you must meet in order to be in the new streamline. There's 2 different programs, those for domestic and those for foreign. Okay, we'll talk about what the definition of a foreign resident is momentarily. But you always have something called a quiet disclosure. Now, this is something that we've been using, it's a technique we've been using for years. You quietly get returns into the system. You hope it'll be below the radar, and at least you're in the system, and you hope that the IRS won't raise any questions. The concern that you have is with the electronic filing of FBARs, and consequently what happens is that there's an ability by the IRS or the Treasury Department to be able to ascertain whether these were filed as part of a program or not, or alternatively, was there any history of filing FBARs up until recently? So there's a potential for more focused inquiry. The other alternative is that it's only going to take care of things going forward. You have the risk for the past. Or sheva al taseh. Ladies and gentlemen, I must tell you, in light of the program and the discussions that we've had so far, whether that's from an Israeli perspective or from an American perspective, sheva al taseh really doesn't work anymore. And I'm a strong advocate, as have many of my colleagues, that you need to take a much more proactive role in these things. Okay, so let's figure out what are the opportunities. Let's figure out, again, what was a way of solving it. The good news about the IRS program is that it's the streamline. The not good news is that the new offshore voluntary program got rid of the foreign resident 5% mitigated reduced FBAR penalty. And now you got 2 categories, 27.5% or 50%. Number 2 is that you have to pay the FBAR penalty at the time of submission. Under the old programs, you didn't have to pay the FBAR penalty until you completed it and signed the 906 closing agreement. Number 3 is the fact that there is much more information included in the IRS's intake forms, and unfortunately, the IRS processing time is getting longer and longer because there are thousands of cases, even from as far back as 2011, that haven't been resolved. Now, the funny thing about that is, that's actually a bracha. It's actually a blessing in disguise. Because of the fact, the cases that have not been resolved have an opportunity to try and to transition. But again, understand, before we get into the transition rule, this is something brand new under the offshore program, which is that, remember I mentioned there's only 2 categories, 27.5% or 50%? This is the current hit list. If you have any account and you submit after July 1, and these accounts are at these distinguished banks, I only got a little chuckle for the title distinguished banks. Okay, what can I tell you? Consequently, what happens is that your FBAR penalty is increased to 50%, a very, very hefty penalty. So this is clearly a situation where proactiveness done in the past would have preserved a much, much lower rate. And just to show you, ironically, that if you would have had a UBS account and have been a foreign resident and been in the program prior to July 1, 2014, you still could have gotten an opportunity to get 5%. Now, that has gone up to an extra 0 to 50%. Okay, again, I don't mean to focus on UBS, but that has become a much higher topic and a much more emphasis is placed even in Israel. Because truth be told, just like, as I mentioned up front, there was this concept of this avalanche, and in order to have an avalanche, it's the straw that breaks the camel's back. Just like, for example, what started everything in the United States was the DOJ's, the Department of Justice, ability to break through the secrecy with the UBS situation. UBS is the bank in Israel in particular that the Mas Haknasa has began to garner information from. as you may have read recently in the newspapers, which has caused the Mas Nasa to now go after people who have not disclosed the information. Now, I have at the bottom of the list here a little bullet. And the bullet states as follows: when or if Israeli banks going to be added? And it's interesting, this list has not been updated since June 20th. And there are ongoing discussions between the Department of Justice and various Israeli banks. We know that one in particular, Bank Leumi, the largest, has already had a provision for a few hundred million of shekels in order to deal with the penalty. But the good news is that that bank, thank God, has not yet been added to this list, let alone any of the other potential banks. And the question will be is that if that bank or any of those banks get added to the list, that will then concomitantly, it'll also significantly increase the risk in connection with not only an offshore voluntary program filing, but also as it relates to certain streamlined ones. Okay, so good. So what happens over here? I've got the streamlined program. You have to be able to prove that it's non-willful. The case, again, the fact pattern is green card holder, U.S. citizen. I have not done anything up until July 1. So it's now November 19th. So what am I going to do? I'm going to go to a professional, or, although sometimes people think they know better, they'll do it themselves. I would not recommend that. But what happens is that you need to file certain forms. Okay? And what happens is there has an opportunity to file 3 years tax returns, 6-year FBARs, and a non-willful statement. And if you qualify for foreign residence, okay, it's a 0 FBAR penalty. Or if you're not a foreign resident, you're a domestic resident. Now, what's the definition of foreign resident? Normally, we would have said, not a problem. You live overseas. Where is your tax home? However, the IRS has recently stated that this look-back period of 3 years, you actually have to have been there at least 330 days in one of those years in order to be able to meet the foreign resident exception. Now, the problem is, can you in fact attest to that? Means you're, again, 330 days outside the United States. Okay? Because you need to attest under penalties of perjury that in fact you meet the criteria. Okay, and the question is that, does that work or not? If you don't, or what happens if you're unsure, do you go ahead and still file for it? Okay, again, this is what they've recently said. Whether it's correct or not is a different issue, but this is at least what they're saying. If not, then you may have to go the domestic route and still have a 5% FBAR penalty. But again, it begs the question, what does non-willful mean? Okay. So again, file 3 years tax returns. Understand that the look-back period typically is 11, 12, and 13, but it would be 2010, 11, 12, if in fact 13 is on valid extension. Number 2 is the fact, as it relates to the 6-year FBARs, you've got 8, 9, 10, 11, 12, and 13. Understand that the form that the IRS uses, this form 14653, it's very interesting because it only has a page and a half for foreigners, and I think it's 6 pages for domestic people. People who live in the United States, much more extensive information. And you have to sign on the penalties of perjury. So the question is, willful, not willful. Was the willful failure to comply with the IRS tax rules non-willful? What does non-willful mean? Okay? Very little guidance. How risky is it? Some traps. So here's some thoughts for you to think about. Number 1, if you put any information, as Bob said before, the information, the disclosure has to be full and complete because you're never really quite sure what data and what information the IRS already has garnered. And anything you put under penalties of perjury that's not correct, you've set yourself up for criminal prosecution. You literally fell on the sword. So each of us have to make sure that we really drill down and emphasize and try to ensure that we have a good handle on the things. But number 1, which country were the accounts maintained in? Did those countries have secrecy? Number 2, was an entity used? Number 3, was the account moved over the last few years? For example, could have been in Switzerland, and next thing I know it goes to BVI, or it went to Singapore. Okay, why did it happen? Because the UBS banks, the Swiss banks, basically said, move it. Okay? Were there large withdrawals during this period of time? Did you ask for the mail to be held? Was it a managed account? So much of this really relates to figuring out the specifics. However, I'd like to humbly suggest something, and this is very important. When we do these cases, you really got to drill down and know the client, meaning as follows. You need to develop and understand the history of the funds. You'd be surprised when you get the clients to relax and you get the clients to start to trust you and then to share information about some things from the past, from the Holocaust, from reparations, all types of situations. And the question can become is that can you use any of that in an artful manner? Now again, if it's all new and fresh, much more complicated to do that. But still, is there an opportunity? One of the advantages that exists under those cases that are in the program, okay, is the fact that, again, you filed OVDP prior to September 2012. Is that of course you could try to streamline and see if it works. If they don't accept it, you're still in the offshore voluntary program. But there is a special nuance that we've discovered in interacting with the IRS of late. And by the way, over the last 6-8 weeks, the IRS has been much more forthcoming in trying to help, very sincerely and genuinely, out in the field. And again, part of it depends on the relationship, the credibility, and the integrity you have. But here's an interesting opportunity. Of course, besides the program itself, you can always opt out and be exposed to potential penalties, but you may end up doing better. But you can stay technically in the old OVDP, you can secure to 5%, or you can request a transition, or, okay, you can do something else, okay? You are non-filer since 2009, you're a foreign resident, you can't use the mark-to-market elections, but what you're basically asking for is a creative opt-out under the modified 2012 streamlined program. Recently, we were working some cases, and the IRS actually suggested we use this. Now understand, when you're doing this, you're not going to have any delinquency or FBAR penalties. Now the FBAR penalty, okay, that's one thing. Obviously it's significant. But the delinquency penalties may be huge. The failure to file and the failure to pay may be significant if it turns out, for example, people live in Israel and they've had a very large investment portfolio of ribbit. Well, understand, in Israel, the rate on interest is probably 50% lower than it is in the United States because it's ordinary income. So you may have a huge amount of ordinary income. You may have a huge amount then of failure to file, failure to pay penalties. So one way of potentially alleviating it is to say, I'd like to opt out, but go under the modified, better enhanced, new streamlined treatment. The chisaron in that is you don't have a formal 906 closing agreement. On the other hand, you in some respects are actually having to trust the IRS that they believe that this is going to be accepted. Because what happens then is that it gets approved at the manager level, goes up to territory manager level, and then it's got to go to the committee. But you're hoping that you've established enough credibility when you work with them and they say, we think it has a good chance that it's really worth the risk. Okay? Just a few other thoughts, because one of our managing directors in the front here is telling me I'm almost out of time, is the fact that understand that notwithstanding the new treatment, if you have cases where you have just not disclosed the existence of the foreign bank accounts, but you do not technically have unreported income, there is a new procedure to file that. That used to be known as FAQ 17. There is a new successor program for that. You can still get it in the system. It can be protected, and it will then basically avoid penalties going forward. But of course, you need to make sure that there was no unreported income. In addition to which, what ends up happening is that we're now in a mode. And the mode basically is you've got alternatives, but at the same time, it also places a tremendous level of responsibility on the taxpayer family, and the professional. Because whatever you're going to put into a non-willful statement, it must be 100% accurate. And you've got to be not only accurate, but you also have to be able at the same time to tell the story. I'm not talking about the easy cases where people have lived overseas. You know, the parents came to America for a year or two for higher education, and they came back. And they've been in Israel, you know, for the rest of their life. That's the easier cases. I'm talking about, for example, where somebody came to America to work for 5, 6, 7 years, or continued to file U.S. tax returns. I mean, we've got cases where, notwithstanding the fact that returns have been filed continuously in the United States, and the return preparer still used the taxpayer's Israeli resident. There was never a checking of the box indicating they had foreign bank accounts, even when they included, in some cases, interest, rebit, from some Israeli banks. Okay, number two is the fact that there also was never filings of the FBARs. So each case, the most important thing you can take out of today's presentation is one size does not fit every situation. Number two is the fact is you must open up and share. Your clients have to share the information and not have a situation where they hold off and thinking that you don't need to know. Because at the end of the day, the potential adverse effect is much, much greater than using one of the alternatives. And finally, interestingly enough, over the last 2 weeks, it used to be that everybody was concerned about the quiet disclosures, okay? Now, quiet disclosure is, again, as we mentioned, you just put it into the system and you hope for the best. There's also an opportunity as part of that where you put some type of a narrative involved. Very recently, there was a case where it was a quiet disclosure. Normally, the agents from the fraud referral unit of the IRS would have come out and met with the person. But surprisingly enough, what ended up happening is the Austin Service Center, the Austin, Texas Service Center, which is the repository for all of these cases, sent a letter to the taxpayer. And they said, "Hi, Mr. So-and-so. We noticed you filed, but guess what? You're not part of the Offshore Voluntary Disclosure Program. Please consider coming into the program." Does that mean that the IRS is being nicer and more gentler? I think what they're doing is they're realizing that people give them one last chance. Again, don't think as though that case is going to be a wonderful transition case, okay? Unless, of course, the facts support it. But at the same time, there are still new opportunities. Take advantage of those situations, especially in light of the fact that the world is becoming a much, much smaller place because of the overlap of FATCA and what's going to be coming in the future. So please don't have our clients be lulled into a false sense of security. This is clearly a situation where proactive conduct is essential. And then you do the prerequisites in order to be able to expatriate, which is a nice lead-in for my esteemed colleague who will follow after me to talk about expatriation and getting out of the tax system. Thank you again. It's indeed a pleasure, and look forward to following up with you.